to this. Very good. So I'm going to have to do it this way. No problem. If you have questions, please write your question in the chat box, or and there will be a question and answer session afterwards, or after the program ends, you can either email me or call me with a question. I'm happy to answer. So I'm an attorney with more than 30 years of experience. As Carol said, you see my areas of expertise. And I'm moving on. I also host a podcast. If you like podcasts, everything about law in Long Island, you might find it interesting. Tonight, our discussion is elder law and estate administration. So I think it's helpful to start with definitions so that we all know what we're talking about. So you see here, it's a definition from Wikipedia. Elder law deals with issues involving the aging population. The idea is to help those of us getting older, I include myself in that category, to maintain financial freedom and autonomy. And that's done through financial planning and long-term care planning. The issues involved in elder law include estate planning and administration, so planning for what happens in case of incapacity or death. And I just want to say here, the word estate has a meaning that I want to make sure we all understand. It means someone has passed. So you wouldn't say the estate of Zahava Schechter because I'm still alive. So estate planning is planning for when you need an estate. And administration is after someone dies. We are going to talk about tax questions as well. Elder law includes also Medicaid and disability, as well as guardianship and fiduciary issues. So I want to start by saying Medicare and Medicaid are not the same. A lot of times people call me or they meet with me in my office and there's a misunderstanding. So let's talk about this. Medicare benefits are age-based. What does that mean? You could be Warren Buffett or Bill Gates, over 65, billionaires, and you still may receive Medicare benefits. Medicaid benefits are needs-based, meaning you have to be poor. So you could be 1 day old, or you could be whatever age. It deals with money, but Medicare does not pay for long-term care. So if you're well and you can afford long-term care insurance, I highly recommend it. Okay, we're going to go down. I know it's hard to see this, but I tried to make this a bigger page. This is the 2023 New York Medicaid long-term care eligibility for seniors. And you see here for Medicaid, what the income limits are. You can find this in bigger print if you go onto Google, 2023 New York Medicaid long-term care eligibility for seniors. So it depends on whether you're single, married, both spouses are applying, or married, one spouse applying. But let's just take the single right now. As you see, your income limit, the amount that you can receive for income on a monthly basis and qualify for Medicaid is $1,677 per month. And the asset limit is $30,182. So most of us on Long Island own a house, have bank accounts, etc. You're probably going to be over that limit. There are ways to get around it, but that's beyond this program. But just be aware of what the limits are. So if you're applying for Medicaid, and I mentioned this, we will talk later about irrevocable trust, which sometimes people use to qualify for Medicaid. The current Medicaid look-back period for a nursing home is 5 years. So if you're thinking of transferring a house, a lot of people call me a lot and say, I want to keep my house, but I also want to qualify for Medicaid. I don't want to spend down all my money so that I have nothing left for my children. You really can't have it both ways. Either you lose control of your assets so that you qualify according to the limits that we just looked at, or you keep your house. Maybe you have to sell your house in order to pay for your long-term care. For community, which is assisted living, think of the Bristol or the Atria or any of those places. Actually, the Atria does not accept Medicaid, but the Nautilus, thinking of places, even the Boulevard in Queens, that's 30 months, but more changes are coming. I'm not going to go into estate planning here because I did a prior program, but just know that it's very important when you think about, are you prepared for incapacity or death, what will happen and how will your wishes be honored, you have to have at least 3 documents in place. So the ones that are effective while you're alive are the healthcare proxy, dealing with healthcare decisions, the durable power of attorney, dealing with everything else, money, IRS, Social Security, etc. And what's effective only after you're deceased is the last will and testament. So even today, I met with a client who had first contacted me and said, I need a will. And the point is, if you're going to live for a while, you need more than a will. The will is only effective after you die. So you do need the healthcare proxy and power of attorney to make sure that your wishes are known. So I've interspersed some cartoons here just to bring some levity. Mr. Frosty, it's March. He's going to be melting. Time to talk estate planning. So the idea being the time to do estate planning is when you're well, when you're healthy, when you're able to do so, because otherwise, if you don't have mental capacity, you can't do it. And I just want to say, as we talk about being able to do things, I'm always talking about mental capacity, not physical. Okay, next question, and this is for, I won't call her out, but this is for someone who told me she's very interested in hearing about trust. So what is a trust? A trust is an entity. You can't touch it or feel it, and it's not a person. It's something, if you think of a holding like a container, it holds assets. It is not the answer for everyone. Sometimes someone will say to me, a client will say, oh, my next door neighbor has a trust and said, I need it. Not everyone needs a trust. We'll talk about good reasons to have a trust, but it's not the answer to everything. And certainly you'll see there are some qualifiers. So I want to talk here about, there are many different kinds of trusts, but here we have inter vivos, meaning during your lifetime, or testamentary, that means coming from a will. So what kind of trust you're thinking of setting up is very important. It's very important to understand what your goals are, because it may be that you have certain goals that will not be met, whether through a trust at all or through one or the other. And here I just want to talk for a minute about revocable or irrevocable. Both of these are inter vivos trusts. Revocable means I can revoke it, I can change it, I can add to it at any point. It's mine all the time. It's mine. So it could be it is a Hava Schechter revocable trust. Once I die, it becomes irrevocable, but while I'm alive, it's my money too. Irrevocable, the main reason you would set up an irrevocable trust, which you lose assets, you lose control of your assets, and you cannot change it. The main reason would be for Medicaid planning. Okay, so what are some good reasons to create a trust? It's all about the control. Who gets your money, when they get your money, how they get your money, who gives out the money, what are the circumstances, how do they not get the money? It's all about control and you making the rules. Just remember, if you're keeping control, that means that, you know, you're making changes, you will not qualify, probably will not qualify for Medicaid. And even if you do qualify for some program through, in Nassau County, it's Department of Social Services on Charles Lindbergh Boulevard in Uniondale, I think. Even if you do qualify, after you pass, Medicaid will slap a lien against the house. So they'll take the house anyway. Another good reason to create a trust, and this happens a lot, is your beneficiaries currently receive, or you think they will be receiving, governmental assistance. So if you have a beneficiary who's on Medicaid or social or SSI or SSD or all these other disability programs, if they receive money, they're going to be thrown off the rolls and they won't have those benefits anymore. So there are ways to get around that with special needs trusts, et cetera, but not a regular trust. Medicaid planning, we've discussed. Spendthrift. Let's say you have a beneficiary who likes to spend money on many different things and won't be able to maintain money. So maybe you want to control how much is given when it's given so that it lasts the lifetime of that beneficiary. Addiction, drugs, alcohol, gambling, all the addictions, people who, it's a disease, people who are affected by an addiction, unfortunately go through money very quickly. So you may want to control that. And ease of administration. So I have a number of clients who have assets in different places, different locations, different types of assets, and they just want to make things very easy. One trust holds everything. It's easier for those they leave behind. Those are some good reasons. It's very important to choose your trustee and successor trustee wisely, because the trustee manages your trust, if that's what you're thinking about. May you be the grantor, that's the person who sets up the trust, the trustee, the person who manages the trust, and the beneficiary, the person who receives the benefit of the trust. Absolutely, that's what a revocable trust is. I do want to talk about taxes. We will talk about other taxes as well. New York State 2023 estate tax exemption. That means if you have it, if you take a picture of all of your assets at the time of your death, if you have less than $6.58 million, your estate will not be taxed. There may be other taxes, but you will not have estate tax. And the federal is 12.92 million per person. And unlike New York State, the federal allows what's called portability. Couples can add their 12.92 million together. And if you're in between the two, then meaning you have more than 6.58 million, but less than 12.92 million, you have to pay the New York estate tax. I will tell you, estate tax is high. So there are many ways that you could try to make it so that you do not have estate tax. But again, that's for another conversation. So we've talked about elder law, we've talked about estate tax. I want to move on to estate administration. So again, estate means somebody's passed. There are two ways to handle the affairs of someone who dies. Actually, there are many ways, but we're going to talk about administering it in general. Either there's a will or there's no will. And if there's a will, that's called probate. Probate, you can think of as acceptance. It's like the court accepting the will. So you may think you have a will, no problem, right? Well, not exactly. The court still has the not only obligation, but the right to say, no, we're not going to probate your will. It's against public policy. It's not executed properly. There weren't witnesses. You didn't sign it, all kinds of things. So not every will is probated. Most are. Not every will is probated. Administration is where there's no will. So I just want to say, before we move on to the other questions, what's happening in Nassau County Surrogates Court right now? So Surrogates Court is the court in New York State that has sole jurisdiction, sole ability to hear cases involving dead people. So which surrogates court? Every county has its own surrogates court. If you're a resident, this is your place of where you live, what's on your driver's license, what's on your tax returns. This is your residence. Nassau County, that means the petition, that's what it's called, the request to probate or to administer without a will, is filed in Nassau County Surrogates Court. So actually, I was surprised. Before COVID, if you had a will and it wasn't complicated, I was getting letters, that's the appointment, within a week, even a week, 2 weeks, very quickly. During COVID, of course, people were home, meaning the employees were home. A lot of Nassau County employees have left the court system. And so it was taking many, many months. But in the last, I'll just tell you, I just got my client appointed, and it took about a month. So that's good. That means they're catching up. But hopefully it will go down. So yeah. Anyway, what happens to the power of attorney and the healthcare proxy after death? So as I told you before, those documents are only good while you're alive. So they're no longer valid. Who has standing? I'll explain that in a minute, to file this petition, whatever kind of petition it is. So standing means who is directly affected by the death of this person, whether you're named in a will, whether you are an heir at law, or next of kin, or a distributee. They're all the same things. We're going to look at SCAPA, that's Surrogates Court Procedure Act, Section 1001. We're going to look at that in a minute. Petitions filed, I just said where the person lives. So for example, let's say I live in Nassau County, but I'm on vacation in Alaska, and I die in Alaska. So Nassau County has jurisdiction, has the right to hear my case, not where I die. Okay. Who needs to be notified when a petition is filed? Anyone either affected because of a will or adversely affected, who is a blood relative. So for example, if you're in a second marriage and your spouse has children from a prior marriage, those are not blood relatives. They don't have to be notified, even if, a stepchild, a step parent, a step whatever, they're not notified. But a half sibling is. A half sibling is considered like a whole sibling, an adopted parent, legally adopted, through the court system, adjudicated. That person does need to be notified as with a half. So we'll see this going on. So who has the power to act, when, and how? A lot of people think, oh, in the will, it says the Havashekter is the executor. That's the person who can handle, marshal all the assets and then distribute. No, it doesn't work that way. The court has to first admit the will to probate and issue letters, whether letters testamentary, if there's a will, maybe you're familiar with these terms, letters of administration, if there's no will, and only then may the executor or the administrator act. So that's why when a lot of people do planning, whether through trusts or through other means, also we're going to talk about beneficiary designations. That's a great way to do estate planning. Only you can do it on every account, every insurance policy, everything, even checking accounts. It's a great way to do to do estate planning, and it's free and only you can do it. So I make my living by handling a lot of estate issues, both while people are alive and then after they die. I handle a lot of contested, that means they're arguing, the family is arguing about the money. Yesterday, I got a call from a son, most of these people are in their 50s and 60s, from a son who is unhappy with his mother's will, and he wants to contest the will. And most of these kinds of cases really aren't about the will. They're really about what happened when everybody was a child and mommy loved me more or loved you more or whatever. So what I would say to you is, if you have an issue where you're not thrilled with the will or you're not talking to your siblings, the best thing to do is just allow the probate, finish it, and then you can go your separate ways. Because what happens when you fight the will is the only ones who win are the lawyers. I say that honestly. Money does strange things to people. People think that they're entitled to receive money from a parent. So I should tell you, there's only one person you cannot disinherit. That is a legally married spouse. Other than that, you can disinherit everybody. You don't have to give any money to a parent, to a child, to a sibling, anybody. But a legally married spouse, you cannot disinherit. That's beyond the discussion here, but that legally married spouse is entitled to not less than 1/3 of your estate. Okay, I'm going to move on to who gets to be the fiduciary if there's no will. So this is SCAPA, Surrogates Court Procedure Act, Section 1001. Letters of administration are granted to people who are distributees, that's heirs at law, in the following order. Number one is surviving spouse. So if you have a surviving spouse, that means my husband died, I survived. And if I am not a criminal, because if I have a criminal record, a felony record, I will not qualify. And if my FICO score is really bad, or I've declared bankruptcy, I also will not qualify. And if I'm mentally incompetent, I will not qualify. But other than those three things, if I'm pretty normal, otherwise, I win. Even if my children want to be the administrator, want to be the fiduciary, the person who does the work, they won't win. So this is the order in which the court decides who gets to be the administrator. And I just want to say one thing. The surviving spouse may not be the parent of the children, right? It might be a second, I have one of those now going, a second marriage. So the surviving spouse is making decisions, and the children, the adult children from the first marriage, aren't too happy. But that's how it goes. They fought and they didn't win. Okay. I want to move on to, let me see if that works. Yes, the role of the public administrator. I've got 2 of those cases going right now, maybe 3. So the worst thing that you could do, anybody, is not have a will, not have a healthcare proxy, not have a power of attorney. Why? Because if you don't have these documents, then everybody's going to fight. I want to talk about the will for a minute. In a case where, and I have a new client now who isn't married, doesn't have children, parents are dead, doesn't want the siblings to get, and he's going to make a will, which is a very good decision for him, because if not, and if his siblings don't live, it's going to go to the public administrator, which in every county there is someone named the public administrator who is appointed by the court and who handles basically cousins cases. It's very expensive. It's very time consuming. It would all go away. There would be no need if people had wills, but not everybody has a will. Who inherits from the decedent if there's no will? The decedent is the person who has died. Okay, we're going to talk about that in a minute, but first we have another cartoon. No, you cannot get a $5 advance on your inheritance. Okay, so who inherits if there's no will? So if we have a nuclear family, mom and dad or husband and wife with 3 children, if dad dies, then the distributees are mom and the 3 children. The way it works is you first go to the side to a spouse, if there's no will, and children, or if children die, then grandchildren, before you go up and to the side. So let's look at the law. If a decedent is survived, so I'm just going back to this picture for a minute. The decedent, we're going to name dad, sorry. We're going to name dad as the decedent, okay? If dad is survived by his wife and issue are children, the wife gets the first $50,000. She also gets 1/2 of the rest. And the balance goes to however many children. So for example, let's take an example of $100,000. If dad dies with an estate of $100,000, mom gets the first $50,000, and then she gets half of the remaining. So the remaining is $50,000. So she gets another 25. She ends up with 75. And the 3 children share 75. Share 25. So it's like 8,000, whatever, a little more than 8,000, $8,333, I think. So that's how that works. If there is a spouse, I'm on 2 now. This is from the law. If there is a spouse, but no children or grandchildren, then the spouse gets everything. If there are children or grandchildren and no spouse, then the children get. By representation, meaning if there's a child who predeceases the dad, let's say child 1 died before dad, then if that child left children, meaning grandchildren of dad, I hope you're following, that grandchild takes in the child's place. So then it keeps going down. Maybe you've heard this word persterpes. It means if the person who would normally receive the money, it has not survived. Let's talk about special considerations where family members of beneficiaries receive government benefits. That's important because especially in my kinship hearings now, we have beneficiaries who are going to be thrown off the rolls because they're going to receive an inheritance from these cases. Be careful not to name anybody who receives government benefits as joint owners or beneficiaries of any assets. And this really does require a much longer conversation, but I bring it up because it's important. I want to talk a little bit about guardianship because, one of the sad facts of life is that there are people for whom there is no one to care. And I have a guardianship matter right now. And anyone who is older than 18 years of age who cannot manage his or her needs, personal needs, meaning where he or she lives and how that person is cared for, as well as property and financial affairs, that person needs a guardian. That's brought in Supreme Court because the person's alive. Remember, I said surrogates court is for people who have passed. Guardianship is a legal situation where the court decides that the person is incapacitated and cannot make decisions for himself or herself. Okay. Guardianship of a child. If you have a child under the age of 18, so 17 years or younger, and not married or in military service, and you're the parent, whether adopted or biological, you are that child's natural guardian, at least until the child reaches 18. There are also situations involving guardianship of developmentally disabled persons, whether mental retardation or any other form. Generally, unless it's a very hard case of autism, like with Asperger's, this would not apply. But if you have a case where a child who is becoming an adult child, going from 17 to 18, they're no longer your natural ward, and you need to apply for this. I'm just going through some various issues. Here are some miscellaneous matters that I hope you'll take to heart. Number one, if you have a bank safe deposit box, please close it. Now, if you have a lot of jewels or you have things that you don't want to leave at home, I understand. However, it's much better to have a fire safe box in your home. I can't tell you how many times different institutions have closed or frozen, is more correct, the safe deposit box after someone dies. And then the survivor cannot get in, and maybe the will is there, or maybe there are other documents there. So it's much better to have a home fire safe box. If you need, it's on Amazon or Walmart, $50, and they mail it, they ship it to you, to your home. If you need a link, I'm happy to provide it. I'm a big believer in long-term care insurance. If you can afford it, if you qualify, because you don't have any medical disqualifiers. Life insurance, term life insurance is good if there are people who are dependent upon you. If they're not dependent, I don't know that you need life insurance. Disability insurance is for certain professions. As I mentioned before, please check beneficiary designations on all accounts, including insurance policies. I did quite a few pre-nuptial agreements as well as post-nuptial agreements for second marriages and beyond, but more lately I've been doing for first marriages. People are marrying later, and so one spouse to be has a lot of assets and wants to make sure that if he or she dies or they get divorced, that the assets are protected. And gifting. This year you can give up to $17,000 to any person, and there are no tax consequences. So that's very good. Okay, upper class love. Of course, you can consult with your attorney. I want to talk about deed transfers. People come to me and say, well, what is this about a life estate and transferring deeds? So if you transfer ownership of your property, know that you may lose what's called a step up in basis. Your cost basis is what you paid for the house. So I don't know all the people on this program, but let's say you bought your house in Glen Cove for, I'm making it up, $30,000 50 years ago, 40 years ago, 30 years ago, whatever. And today it's worth $1 million. Well, if you die, your beneficiaries get a cost basis, meaning a tax basis of $1 million. But the kicker is you have to die. If you sell it during your lifetime or you transfer it to your children, they get your $30,000, $40,000 tax basis, and you're going to be paying capital gains tax. So be very careful before you start doing transfers. You should understand. One other thing I want to say to you, and I didn't put it in here, is in Nassau County, if you're over 65, if everybody on the deed is over 65, you can get not an exemption, but a discount on your real estate taxes, which are substantial. They could be $5,000 or more per year. But if you put somebody else on the deed who is under 65, maybe your adult child you're going to lose that tax beneficial treatment. So be very careful before you do it. And I just want to give you some quotes from Benjamin Franklin. If you've heard me speak before, you know I say this quite a bit. Nothing can be said in the world, nothing can be said to be certain except death and taxes. And by failing to prepare, you are preparing to fail. So here, if you have a question, feel free to contact me. Most important thing, to be well. Here is my office information. And now I'm going to stop the recording.